Hello, you're watching Addleshaw Goddard's Employment Channel. In today's programme, finally, the Enterprise and Regulatory Reform Act and the Growth and Infrastructure Act have both received Royal Assent. So we look at the implications for employers. Sally Hulston, one of our managing associates, will give her views on the changes. We've also got 2 new cases on victimisation before we finish up by looking at Henning Berg's controversial sacking by Blackburn Rovers Football Club. So, onto our 2 new acts for today. The Enterprise and Regulatory Reform Act came into force on the 25th of April and will bring a raft of changes to employment law, but all in different stages. The first wave will be on the 25th of June, with most of the other changes coming into force in either October this year or April next year. So what's coming into force in June then? Well, first there's the removal of the qualifying period for unfair dismissal, when the main reason for dismissal is the employee's political opinions or affiliation. So from June, any employee who's sacked because of their political opinions or membership of a particular organisation can bring a claim for unfair dismissal, regardless of how long they've been employed. Secondly, the cap for unfair dismissal compensatory award will change. This will be limited to 12 months' pay, subject to the existing cap of £74,200. This is good news for employers because claimants will be forced to adjust their expectations about the maximum compensation they might achieve, rather than just assuming, for whatever reason, that they'd automatically get the maximum sum of £74,200. We'll also see some changes to whistleblowing in June. Protected disclosures will have to be made in the public interest, but will no longer have to be made in good faith, although compensation may be reduced if there's a lack of good faith. Also, employers will be liable for any detrimental treatment that whistleblowers suffer at the hands of other employees, unless the employer can show they took all reasonable steps to stop that treatment taking place. Finally, EAT judges will sit alone and tribunals will be able to order deposit orders on some or part of a claim. Expected later in the summer, or perhaps in October this year, is the new system of confidential settlement agreements. Under these proposals, any settlement discussions made before termination won't be admissible for the tribunal's consideration in unfair dismissal claims. We've discussed the limitations to these proposals in quite some detail in our programmes in July last year, as well as in February this year. As I mentioned earlier, we're still not quite sure when all the other changes in the Act are due to take place. The government has committed to publishing a detailed implementation timetable shortly. Other changes to look out for, though, include the removal of the discrimination questionnaire procedure, which is great news for employers when it finally happens, the introduction of financial penalties for employers who lose tribunal claims, which isn't very good news for employers, and also mandatory equal pay audits for employers who lose equal pay claims. I asked Sally Hulston then, a managing associate in our employment department, what she thought about the changes coming into force in June.
Thanks, Helen. Well, we were expecting the change relating to dismissals because of political activity for some time following the Redfern case in 2012. And that case found that the UK law wasn't up to scratch with the convention, so people could be sacked because of their political beliefs. So now people who are members of political parties, so Mr Redfern, who was a member of the BNP, they can bring unfair dismissal claims regardless of how long they've worked for the employer. However, dismissals won't be automatically unfair, so employers can still use the SOSR, the sum of the substantial reason for dismissal, if their belief is fundamentally at odds with what they do in their job. Well, in terms of the changes to whistleblowing, it'll be really interesting to see what constitutes in the public interest. I think the change is going to be very good for employers because it should close the loophole that's developed over the years, which has allowed employees to bring a claim for whistleblowing for breach of their actual personal employment contract. So the other thing, though, is that the removal of good faith is going to be less helpful to them. The introduction of vicarious liability for employers for acts that their employees do, I think is going to be a good opportunity for employers to review the policies and look at the training just to make sure that they satisfy the requirement that you've taken all reasonable steps to stop that detriment from happening.
Thanks, Sally. Our second piece of legislation today is the Growth and Infrastructure Act. This Act makes one big change to employment law, the introduction of a third class of employee status, the employee shareholder. This new status will allow employers to offer employees between £2,000 and £50,000 of company shares, in return for them giving up some quite important employment rights. For example, rights relating to unfair dismissal, redundancy payments, flexible working time and time off for training. The idea behind it is that the government feels that smaller businesses are worried about taking on new staff due to the claims culture. This new status will kick in on the 1st of September, and it'll be interesting to see how many companies actually take it up. Sally, what are your thoughts?
Well, I agree, it will be interesting to see how this develops come September. I'm aware that one major concession that the government had to take to ensure that this came into force was employees were going to have to speak to an independent legal advisor before they sign up to this employee shareholder contract. There's also a 7-day cooling off period where the employee can change their mind. I'm not sure though how many lawyers are going to advise it's a good thing to enter into such a contract, signing away all your rights, if you don't get anything significant in return. Yeah. I think it's going to be one of those cases to see practically how it's going to work.
Thanks, Sally. So, a lot to come over the next few months. We'll keep you posted when these changes come in. And now to our cases of the day, which both relate to victimisation. In our first case, the tribunal found that an employee was victimised when she was dismissed from a new job because she'd brought discrimination claims against a previous employer. Although she'd had several chances to disclose these claims to her new employer, she hadn't done so. However, the tribunal didn't agree with her new employer that this in itself broke the mutual trust and confidence between them. The tribunal decided that she'd clearly been dismissed because she'd brought proceedings against her old employer and that the new employer simply viewed her as a troublemaker, which had led them to get rid of her unlawfully. In our second case, the EAT has now effectively plugged a gap in the Equality Act by confirming that victimisation which occurs after employment is unlawful. Currently, the Equality Act clearly covers post-employment discrimination and harassment, but not victimisation. The EAT read the Act alongside European Union law, which forbids post-employment victimisation, and decided that the UK parliamentary draftsman must have intended to include victimisation after employment ends as well. However, this has now been appealed and is heading for the Court of Appeal during the next 6 months, so watch this space. And finally for today, we finish with a footballing tale of woe. Henning Berg was only 57 days into his 3-year contract as manager of Blackburn Rovers Football Club when he was sacked. Unfortunately, it seems that initially the club's managing director promised to pay out the remainder of Mr. Berg's contract. Although the club later tried to withdraw from this by arguing that the MD had acted without authority when he'd made this promise, the High Court kicked this argument into touch. So now Rovers owe Mr. Berg £2.25 million. Now that's a bad day at the office. On that note, that's all for today from Addleshaw Goddard's Employment Channel. Thank you for watching and see you next time.